My husband died 15 years ago. He left me a debt that I paid every month for $500. But one day, I received a letter from the bank. "Your husband never had any debts." When I asked, "Good day, dear listeners. It's Clara again. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled." My name is Dorothy Hayes, and I am 72 years old. I live in the same house where I raised my children, on Elm Creek Road, outside of Columbus, Ohio. A white clapboard house with a green front door and a garden that Edward always said was too ambitious for two people. He was right, of course. He was right about most things. Edward and I were married for 41 years. He worked as a civil engineer for the county, a quiet and careful man who kept a ledger for household expenses in a green notebook and never once bounced a check. We weren't wealthy, but we were comfortable. We paid off the mortgage in 1998. We had two children, Raymond, our oldest, who everyone called Ray, and Carol, our daughter, who moved to Portland after college and called every Sunday without fail. When Edward died of a heart attack in the spring of 2009, I thought the hardest part would be the silence. And it was. The house felt like a museum of a life that had ended. I'd walk into the kitchen in the morning and expect to hear him filling the kettle. And the absence of that sound was a physical thing, like a bruise you keep pressing. But I managed. That is what women of my generation do. We manage. About 3 weeks after the funeral, Ray came to visit. He sat at the kitchen table with a folder in his hands and a look on his face that I now recognize as rehearsed concern. He told me that he had been going through his father's papers, helping me, he said, because he knew I was overwhelmed, and that he had found something troubling. A loan, he said. A personal loan Edward had taken out years ago from a private lending institution to cover some investment losses he'd never mentioned to me. Ray said he'd spoken to someone at the bank and that the outstanding balance was just over $47,000. I remember sitting very still. Edward had never mentioned investment losses. But then, had he wanted to protect me? He was that kind of man, the kind who carried things quietly. I asked Ray to show me the paperwork. He showed me a document. It looked official. It had Edward's signature, or something that resembled it. I was 3 weeks out from burying my husband, and my eyes were not good, and my mind was not sharp, and my son was sitting across the table looking at me with such patient, sorrowful helpfulness that I did not think to question it the way I should have. Ray explained that the bank had agreed to a manageable repayment plan, $500 a month, and he would handle the transfer himself so I wouldn't have to worry about the logistics. He said he'd set up an automatic arrangement. All I needed to do was give him the cash or a check each month. He would take care of the rest. And so I did. Every month for 15 years, I wrote Ray a check for $500. Looking back, I want to ask myself, why didn't you call the bank yourself, Dorothy? Why didn't you ask for the account number, the institution's name, a written repayment schedule? And the answer is as simple and as humiliating as this. Because he was my son. Because I had just lost my husband. Because when you are 72 and grieving and someone you love hands you a piece of paper and says, "Trust me," sometimes you trust them. The letter arrived on a Tuesday in March of 2024. Plain white envelope, the return address of First Midwest Bank printed in the corner. I almost didn't open it. I assumed it was a promotion of some kind, but I opened it at the kitchen table with my second cup of coffee, and I read it twice because the first time I was certain I had misunderstood. The letter stated that the bank had recently completed an audit of dormant and legacy accounts and had found no record of any loan account in the name of Edward Arthur Hayes. It went on to say that if I believed this was an error, I was welcome to contact their customer service department. I set the letter down on the table. Outside, a cardinal landed on the bird feeder Edward had hung from the maple tree in 2003. I watched it for a long moment. Then I picked the letter up and read it a third time. Your husband never had any debts with us. 15 years, $500 a month. I didn't reach for the phone right away. I sat there in the kitchen on Elm Creek Road, and I did the arithmetic very slowly, the way Edward would have done it, in my head without a calculator. $500 times 12 months times 15 years, $90,000. The cardinal flew away. The kitchen was very quiet. I didn't sleep that night. I lay in the dark and stared at the ceiling and tried to find another explanation. Perhaps the bank had made an error. Perhaps Edward had taken the loan from a different branch, under a slightly different account structure, and the audit had missed it. Perhaps Ray had been paying a different institution and had simply used First Midwest's name as a shorthand. I built these possibilities carefully, the way you build a small fire when you're cold, hoping each one would hold. None of them held. Because when I thought about it clearly, and by 2 in the morning I was thinking about it very clearly, there had never been any paperwork beyond that single document Ray had shown me 3 weeks after the funeral. There had been no bank statements mailed to the house, no annual notices, no loan account number I could point to, no record in Edward's green notebook, which I still kept in the drawer beside the stove. I had looked through that notebook many times over the years, and there was no entry for any loan, any investment loss, any debt of any kind. Edward had been a careful man with a green notebook who documented every significant financial event. If he had taken out a loan for $47,000, it would have been in the notebook. It was not in the notebook. I got up at 5:30 and made coffee and sat at the kitchen table with the bank letter, the green notebook, and a yellow legal pad. I wrote down everything I could remember. The date Ray had first told me about the debt. I looked it up in my own diary, which I have kept since 1987. April 14th, 2009. 3 weeks and 2 days after Edward's funeral. I wrote down every check I could trace. I had kept my check registers because Edward had taught me to, and they were in a shoebox in the closet, going back to 1991. I spent the morning going through them. 180 checks, each for $500, made out to Raymond Edward Hayes, not to any bank, not to any lending institution, to my son. I sat with that fact for a long time. The coffee went cold. The morning light moved across the kitchen floor the way it always does, that slow diagonal shift from the east window. And I watched it move, and I thought about Ray. I thought about him as a boy, helping Edward rake leaves. I thought about him at his wedding, crying during the vows. I had thought it was love. I thought about Thanksgiving dinners and Christmas mornings, and the way he used to call me every few weeks, reliably, warmly. The calls had become less frequent in the past 2 or 3 years. I had told myself he was busy. Had he been avoiding me? Or had he simply become comfortable, the way a person becomes comfortable, with an arrangement that has gone unchallenged for 15 years? I thought about Linda, Ray's wife. They had been married since 2003. Linda was a composed, well-dressed woman who worked in real estate and had very firm opinions about most things. She had never been unkind to me, precisely, but there was something in her manner, a certain measuring quality, the way she looked at the house when they visited, the way she had once commented that the property must be worth quite a lot now, the market being what it was. I had taken it as small talk. I was less sure of that now. Had Linda known? Had this been her idea? I stopped myself. I was not going to spiral into accusations I couldn't prove. That was not how Edward would have approached this. I needed facts. That afternoon, I called First Midwest Bank directly, the number on their letterhead, not any number Ray had ever given me. And I spoke to a woman in their records department named Patricia. I explained that I had received a letter regarding my late husband's account history and asked if she could confirm, in writing, that no loan account had existed in his name. She was professional and patient. She said she would have a written confirmation mailed to me within 5 to 7 business days. Then I called Carol. Carol answered on the second ring, the way she always does. I told her I needed to talk, that it was important, that I wasn't in any danger, but that I needed her to listen without interrupting. She said, "Mom, you're scaring me." I said, "Good. Then listen carefully." I told her everything. There was a long silence after I finished. Then Carol said, very quietly, "How much, Mom?" "Total?" I told her. Another silence. Then, "We need to get you a lawyer." That was exactly what I had been thinking. I didn't want to call the police yet, not until I had more than a bank letter and a shoebox of check registers. I didn't want to accuse my own son of fraud based on evidence that a good attorney might dismiss in 5 minutes. I needed to be certain. I needed to be organized. I needed to walk into whatever came next with something solid in my hands. So I made a list, a real list, the way Edward would have made it. Step 1, get the written bank confirmation. Step 2, find a lawyer who handled financial fraud and elder exploitation. Step 3, gather every document I had before anyone, including Ray, knew that I was looking. That last part was important. Ray called me every 2 weeks or so. The next call would come in about 10 days. I needed to act before then, and I needed to act quietly. I am a 72-year-old widow who grows tomatoes and reads mystery novels and makes pie crust from scratch. Ray had counted on me staying exactly that. He had counted on me never asking questions, never checking, never adding things up. He had forgotten that his father taught me to keep records. The written confirmation from First Midwest Bank arrived on a Thursday, 7 days after my phone call to Patricia. I recognized the envelope immediately, the same plain white with the blue return address, and I opened it, standing at the mailbox rather than waiting until I got inside. The letter was 2 paragraphs. It confirmed, in formal language, on bank letterhead, that a search of all records associated with the name Edward Arthur Hayes and his Social Security number, which they had verified from the account information I'd provided during my call, had produced no evidence of any loan, credit facility, or outstanding debt of any kind. The letter was signed by a department manager and included a direct contact number. I folded it carefully and put it in the manila folder I had already labeled, in pencil, Bank Correspondence. I had started a filing system on the dining room table, which I hadn't used for actual dining in years. It was where I did puzzles and paid bills and kept things I was working on. Now it held 4 manila folders, a legal pad with my timeline, and the shoebox of check registers. 2 days before the bank letter arrived, Carol had called me back with a name. Margaret Ellison, an attorney in Columbus who specialized in estate fraud and elder financial exploitation. Carol had found her through a colleague at her university. Carol teaches literature, she knows how to research, and had already spoken with her assistant to explain the general situation. Ms. Ellison's office called me the following morning and scheduled a consultation for the coming Monday. I drove myself to Columbus. I want to say that plainly because some people, Ray included, had begun treating me as though I needed to be driven to appointments, as though I might get confused. I drove myself. I found the parking garage. I rode the elevator to the 4th floor, and I sat down across from Margaret Ellison, who was perhaps 60, with silver hair cut short and reading glasses on a chain, and I put my manila folders on her desk, and I told her everything from the beginning. She listened without interrupting. She looked at the bank's written confirmation. She looked at my check register copies. I had photocopied each relevant page before putting the originals back in the shoebox. She looked at my timeline. When I finished, she was quiet for a moment. Then she said, "Mrs. Hayes, what you're describing is elder financial exploitation under Ohio Revised Code 2913.02, theft, and potentially also fraud. The fact that checks were made payable to your son personally rather than to any financial institution is significant. The absence of any loan documentation beyond a single unverified document is significant. and the duration, 15 years, is significant in terms of both damages and the seriousness of the charge. She asked if I still had the original document Ray had shown me in 2009. I told her I had never been given it to keep. Ray had shown it to me across the table and taken it back with him. She nodded, as if this were exactly what she expected. She said that would be a point of investigation. She also said she wanted to request a formal forensic review of Edward's financial records from the county, public records connected to his employment and pension, to establish with certainty that no loan had ever been taken out through any institutional channel. I retained her that afternoon. I wrote a check for the consultation fee and the initial retainer, and I drove home on Route 70 with both hands on the wheel and something settled in my chest. Not happiness, but solidity. Now, the question I had been turning over all week: did Ray know anything yet? 3 days after my visit to Margaret Ellison's office, he called. It was a Sunday, which was unusual. Ray typically called on Thursdays. I answered, and we spoke for perhaps 15 minutes. He asked how I was feeling, whether the garden was coming along, whether I'd had any issues with the furnace. Normal things. But twice he mentioned, almost in passing, that he and Linda had been thinking about the future, and that they might want to sit down with me soon to talk about the house. About the house. I kept my voice pleasant and even. I said that would be fine, that we could find a time. I asked about the grandchildren. He relaxed. By the end of the call, he sounded like himself again. But that phrase had not been accidental. Ray did not make accidental remarks. Either someone had mentioned to him, perhaps a mutual acquaintance in the banking world, perhaps simply his own anxiety, that something was being looked into, or he was making a preemptive move, establishing a conversation about the house before something disrupted his position. Either way, it told me that my window was shorter than I had thought. I called Margaret Ellison first thing Monday morning and told her about the call. She said to document it, date, time, exact wording as I remembered it. I added it to the legal pad. The hard evidence arrived on a Wednesday, 10 days after my first meeting with Margaret. Her office had retained a forensic accountant, a man named Gerald Foss, and he had done something I would not have thought to do myself. He had pulled the public records of Edward's county pension account, his 401k disbursements, and his credit history for the years 2000 through 2009. What Gerald Foss found was this: Edward Hayes had never carried a balance on any credit product above $1,200 at any point in his adult life. His credit score at the time of his death had been 791. There was no record anywhere in any database of a private loan, a personal lending arrangement, or any investment account that had experienced significant losses. More than that, Gerald had found something else. Ray's personal financial records, accessible through a civil search Margaret had filed, showed a deposit of $47,000 in April of 2009. The same month he told me about the debt. The deposit had come from the sale of a used boat, and a second source listed simply as personal transfer. A personal transfer in April 2009 for a significant sum. I sat in Margaret's office and looked at that document, and I felt something shift in me permanently. This was not a misunderstanding. This was not a bookkeeping error. This was deliberate. Ray had come to that kitchen table 3 weeks after his father's funeral with a forged or fabricated document. And he had looked at his grieving mother, and he had decided to take $90,000 from her, $500 at a time, over 15 years, because he believed she would never check. I was 60 years old when it started, not an invalid, not incompetent, simply trusting. Margaret asked how I was doing. I told her I was ready to proceed. The civil suit was filed on the second Thursday of April, 2024. Margaret had prepared a formal complaint citing theft and elder financial exploitation under Ohio law, naming Raymond Edward Hayes and his spouse, Linda Christine Hayes, as co-defendants on the basis that Linda had benefited materially from the funds. The complaint sought recovery of the full $90,000, plus statutory damages, legal fees, and interest. Margaret had also filed a request for a temporary restraining order preventing Ray from accessing or transferring any assets during the proceedings. A standard protective measure, she said, though she warned me that a judge would need to approve it at a hearing within 14 days. I had not told Ray the suit was coming. He found out from his own attorney, who received the formal notice on a Friday afternoon. Ray called me that same evening. I knew from the first second that something had changed. There was none of the careful warmth he usually deployed. His voice was tight and fast. He said, "Mom, I need you to tell me what you think you're doing. Not hello. Not Mom, are you all right? What you think you're doing." I told him, calmly, that I had retained an attorney and filed a civil complaint, and that any further communication should be directed to Margaret Ellison's office. There was a pause. Then he said, "This is a mistake. You are making a terrible mistake, and I need you to stop this before it goes further." I asked him to direct further communication to my attorney. Then I said goodbye and ended the call. The following Saturday, 8 days after the filing, Ray and Linda arrived at my house unannounced. I saw Ray's silver Lexus from the kitchen window, and I felt my stomach tighten, the way it does when something you've been preparing for finally arrives. I had expected this. I had told Margaret to expect it. She had told me not to let them inside if I felt unsafe, and to call her if anything escalated beyond verbal pressure. I let them in because the alternative felt like hiding, and I had not done anything wrong. They sat in the living room. Linda did most of the talking, which told me she had prepared. She spoke about family, about reputation, about what this would do to the grandchildren. Our grandchildren, she said, as though reminding me, if this became public. She said that Ray had made some mistakes in how he handled the paperwork after Edward's death, that it had been a difficult period for everyone, and that the figure I was claiming was exaggerated. She used the word exaggerated twice. She said that if I pursued this, the family would never recover, and that I would spend whatever years I had left estranged from my son. Ray said almost nothing. He sat with his hands folded and looked at the floor in a way I recognized from when he was a teenager, getting a lecture he'd already decided to dismiss. I listened to all of it. I did not interrupt. When Linda finished, I said quietly that I understood her concerns, that I wished things were different, and that my attorney's contact information had already been provided, and all communication should go through her. Linda's composure shifted. Just briefly, just a crack. But I saw it. She said, "Dorothy, don't do this. You don't know what you're starting." I said, "Linda, I know exactly what I'm starting. Please go." They went. I stood at the front window and watched the Lexus back out of the driveway, and I breathed very deliberately. In through the nose, out through the mouth, the way my doctor had taught me for my blood pressure. My hands were not shaking. I noted this with some surprise. When the car had gone, I went to the kitchen and called Margaret and told her what had happened. She asked me to write it all down, what was said, who said it, the specific phrase, "You don't know what you're starting." She said that phrase might become relevant. Then she said something that I found steadying. "You did exactly right, Dorothy. You remained calm, you didn't engage in the substance of their arguments, and you ended the meeting. That's the right behavior." The next morning, I called Carol and told her about the visit. Carol wanted to fly in from Portland immediately. I told her to wait. There would be a time when I needed her present, but that time was the court hearing, not now. She agreed reluctantly. I gave myself 4 days. I didn't read the legal pad or open the manila folders. I worked in the garden. The tomatoes were going in, which is always an act of optimism, pushing something into the ground and trusting it will grow. I made soup. I read 2 mystery novels. I called my friend Margaret Kowalski. Different Margaret from my attorney, a woman I'd known since the 1980s who lived 3 streets over. And we had lunch on her back porch and talked about her grandchildren and the price of groceries and the cardinal that had been visiting her feeder, which I suspected was the same cardinal that came to mine. I did not talk about the lawsuit. I didn't need to talk about it. I knew where it stood. I had done what I needed to do. But on the 4th evening, sitting on the front porch with a glass of iced tea, I found myself wondering, what had that $47,000 been for? What had they bought? What had they done with the $500 each month, month after month for 15 years? A kitchen renovation, vacations, Linda's real estate license? I did not know. And in a way, it didn't matter. But in another way, it was the only thing that mattered, because it was the clearest possible picture of what I had been to them. Not a mother, not a family member, a monthly payment. The offer came by letter, Ray's attorney's letterhead, formal language, and it arrived on a Tuesday, 11 days after the visit to my house. The letter proposed what it called a full and final family resolution. Ray would repay $22,000 in 2 installments, the first within 30 days and the second within 6 months. In exchange, I would withdraw the civil complaint with prejudice, sign a release of all claims, and agree to a confidentiality clause preventing me from discussing the matter with anyone outside the immediate family. The letter described this as a fair and compassionate resolution that preserves the dignity of all parties. $22,000 out of $90,000, and my silence permanently in writing. I read the letter at the dining room table. Then I set it down and looked out the window at the maple tree for a while. Then I picked it up and read it again, because I believe in reading things twice before forming a conclusion. My conclusion was the same both times. I called Margaret Ellison and read her the key terms over the phone. She was not surprised. She said this kind of offer was common, made to test whether I was more frightened of the process than committed to the outcome. She recommended we decline formally and in writing, with a counter letter that made clear we were proceeding with the suit at full value. She would draft it. I told her to proceed. I want to be honest about what I felt in those days. Not triumph. Not even anger, exactly. There was something colder than anger. A settled, clear-eyed refusal. $22,000 and my silence. They thought I could be purchased for $22,000 and a confidentiality clause. That told me everything I needed to know about how they had thought of me all along, as someone who could be managed, appeased, offered enough to make the discomfort go away. I had spent 15 years being managed. I was done. The counter letter went out on Thursday. I do not know exactly when Ray received it, but Margaret told me his attorney called her office the same afternoon, and the conversation was described, diplomatically, as tense. That weekend, Carol flew in from Portland. She arrived on a Friday evening with a rolling suitcase and a paper bag of groceries she'd picked up at the airport market, coffee beans, good dark chocolate, and a bouquet of yellow tulips that she put in the blue pitcher on the windowsill. We sat at the kitchen table until nearly midnight, and I showed her everything: the folders, the timeline, the check registers, the bank letter, the forensic accountant's report. Carol is a methodical reader. She gets that from her father. And she went through each document carefully and asked questions I hadn't thought to ask myself. Afterward, she said, "Mom, I need you to know that I'm sorry I didn't see this earlier." I told her there was nothing to see. Ray had been careful. She said, "I knew he borrowed money from you sometimes. He told me it was small amounts that you offered." I said I had never offered anything of the kind. She was quiet for a moment. Then she said, "I know that now." I appreciated her honesty. Carol has always been honest, even when it was uncomfortable. It's one of the things I valued most in her, and the reason I trusted her with this. Carol stayed for 10 days. She organized the documents into a proper binder with labeled tabs. She sat with me through my second meeting at Margaret Ellison's office. She drove, and I let her, not because I couldn't, but because it was pleasant to have company on the highway. On one of the afternoons she was there, my neighbor Margaret Kowalski came over for coffee, and without my planning it, the conversation turned to the lawsuit. I had not intended to tell Margaret Kowalski the details, but she asked directly. She had seen Ray's car that Saturday and noticed my expression when I came back inside. And I found I was too tired of managing information to deflect her. She listened with her hands around her coffee cup and her expression very still. When I finished, she said, "Dorothy, I had a cousin this happened to. Her son, same thing, different numbers." She paused. "You're doing the right thing. Don't let anyone tell you otherwise." It was a small thing to say, but I had been managing this largely in private for weeks, and there is something about being believed by someone who knows you, not your attorney, not your daughter who has a stake in the outcome, but a woman you've had lunch with for 30 years. That settles something in you. I felt less alone than I had since that Tuesday morning at the kitchen table with the bank's letter. Ray called once more during that period. I let it go to voicemail. His message was brief, his voice careful and controlled. He said he hoped I was well. He said he thought we could still resolve this between ourselves if I was willing to have a real conversation. He said he loved me. I listened to it twice. Then I saved it because Margaret Ellison had told me to save everything. They came on a Sunday afternoon, the first Sunday of May. I saw the Lexus again from the kitchen window, but this time there was a second car behind it, Carol's old Honda, which she had sold years ago and which I did not recognize immediately. Then I realized it was Ray's daughter, my granddaughter Stephanie, 23 years old, sitting in the passenger seat of a rented car that Linda was driving. They had brought Stephanie. I stood at the window for a moment and breathed slowly. Then I went to the door. Stephanie hugged me in the doorway, and she seemed genuine. She is a sweet girl, not responsible for her parents' choices, and I held the hug a beat longer than I might have otherwise. But I was watching Linda over Stephanie's shoulder, and Linda's expression was composed in a way that I recognize now. Practiced. Managed. They came inside. I made coffee. We sat in the living room, all four of us, and for the first 20 minutes, it was almost ordinary. Stephanie talked about her graduate program. Ray asked about the garden. Linda complimented the tulips Carol had brought that were still in the blue pitcher on the windowsill. It felt like a Sunday visit. I believe that was the intention. Then Ray said gently, "Mom, I've been thinking a lot about how we got here. And I want to say that I know I made mistakes in how I handled things after Dad died. I was dealing with my own grief, and I made poor decisions about how to manage the paperwork. But I never intended to hurt you. You have to know that." I said I appreciated that he'd said so. He said, "This lawsuit, it's going to hurt everyone. Not just me and Linda. Stephanie, the boys. His sons, my other grandchildren, 12 and 15, who didn't know any of this was happening. Do you really want that to be what this family becomes?" I said I hadn't started this. Linda came in then, her voice lower and more careful than Ray's. "Dorothy, we're worried about you. We're all worried. The stress of something like this, a court case at your age, it's a lot. And honestly, some of the people you've been talking to, this lawyer, we don't know if she's giving you the best advice, or if she's more interested in her fees than in what's actually best for you." There it was, the first one. I noted it without showing that I had. "We just want to make sure you're thinking clearly about all of this," Linda continued, "that the decisions you're making are really yours. Sometimes when we've been through a lot, it's easy to let other people guide us in directions that aren't actually in our interest. Sometimes when we've been through a lot. She had stopped herself before saying, your age, or at your stage. But the implication was clear enough. I was an old woman. I might be confused. I might be being taken advantage of by my own attorney. My decision to pursue a lawsuit might be a symptom of something, rather than a reasonable response to being defrauded of $90,000. I looked at Stephanie, who was looking at her coffee cup. I said, clearly and without heat, I understand what you're suggesting, Linda, and I want to be direct with you. I am thinking clearly. I have been thinking clearly since I received the bank's letter in March. Margaret Ellison is an excellent attorney, and she is representing my interests. I'm not confused. I'm not being guided by anyone against my own judgment, and I'm not going to withdraw the complaint. A silence. Ray tried again, quieter. Mom, I'm your son. I love you. Please don't do this to our family. And here is the thing about that. It was the right sentence to say to me because I did love him. I did, with all the complicated and durable love a mother carries for a child she has known since before he could walk. And for a second, I want to be honest about this. I felt the pull of it. Not because I doubted the facts, but because love doesn't disappear just because a person betrays you. It just changes shape into something heavier and sadder. But I also thought about the kitchen table in April of 2009. His face across from me, the folder in his hands. Edward had been in the ground for 3 weeks, and Ray had looked at me, and he had lied. I said, Ray, I love you. And because I love you, I need this to be resolved honestly, in a court of law, with proper accounting. That's the only way I know how to do this. Linda stood up. Her composure was still intact, but the quality of it had changed. It had gone from warm to cold, from performed to controlled. She said, You'll regret this, Dorothy. Not a threat, precisely. Just a sentence dropped into the room, like something left behind on purpose. They left. Stephanie hugged me at the door again, and she whispered, I'm sorry, Grandma. I believe she was. I closed the door and stood in the hallway for a moment. And yes, I felt fear. A low, cold, humming fear. Not at what they might do legally, because Margaret had prepared me for every probable move, but at something more personal and harder to name. The fear of being truly and permanently estranged from my son. The fear that Linda's words, you'll regret this, might mean something I hadn't anticipated. The fear that at 72 this fight would cost me more than I'd accounted for. But I noticed something about that fear. It didn't make me want to stop. It made me want to finish. The two things are different. I called Margaret Ellison on Monday morning and told her about the visit in detail. I noted the comment about my attorney's motivations, the implication about my mental clarity, and the phrase Linda had said at the door. Margaret said, document all of it, especially the implication that your judgment is impaired. If they raise that as a formal argument in court, they will need to prove it, and they cannot prove it. She paused and then said something I wrote down on the legal pad. They're scared, Dorothy. Scared people become careless. That's usually when cases turn. The hearing was scheduled for the second week of June. A Wednesday, warm morning, the kind of Ohio early summer that is still more spring than summer if you pay attention. Margaret had told me to arrive 30 minutes early and to dress simply and appropriately, which I would have done regardless. I wore a gray wool blazer over a white blouse and the dark slacks I usually reserved for church, and I drove myself to the courthouse in Columbus. I want to note again that I drove myself. I found parking 2 blocks away, and I walked to the building, and I went through security, and I found the right courtroom on the second floor. Ray and Linda were already seated at the defendant's table when I arrived. Ray looked tired. The specific tiredness of someone who has not been sleeping well, which I recognized because I had worn it myself for several weeks in March. Linda looked as composed as always, but her hands, folded on the table in front of her, were folded too tightly. I noticed this because I have known Linda for over 20 years, and I had never seen her hold her own hands that way. Their attorney was a man named Clifford Vance, perhaps 50, with a good suit and a methodical manner. He had been in contact with Margaret for weeks, and she had assessed him as competent, but not exceptional. The hearing opened with the standard procedural formalities and then moved to the presentation of evidence. Margaret was steady and deliberate. She presented the written confirmation from First Midwest Bank. She presented the forensic accountant's report. Gerald Foss had prepared a formal affidavit summarizing his findings. Covering Edward's clean credit history, the absence of any private loan record, and the April 2009 deposit in Ray's account. She presented 180 photocopied check register entries, each check made payable to Raymond Edward Hayes. She presented the timeline I had assembled, which Gerald Foss had verified against the documentary record. The judge was a woman named the Honorable Patricia Wren, approximately 65, with a measured and unhurried manner. She read each document as it was submitted. She asked clarifying questions of Margaret, precise and calm questions that suggested she understood exactly what she was looking at. Then it was Clifford Vance's turn. His defense rested on two arguments. First, that the original loan document, which Ray had shown me in 2009 and which he now produced for the first time as an exhibit, was genuine and had been sourced from a now defunct private lender. Second, that the checks to Ray represented agreed-upon repayments that Ray had then transferred to the lender on my behalf, and that the absence of bank records was attributable to the lender's dissolution. The document he produced was a problem for them immediately. Margaret had anticipated this and had retained a document examiner, a specialist in forensic document analysis, who submitted an affidavit concluding that the paper stock, typeface, and notarization format of the document were inconsistent with documents produced before 2009. The notary stamp, specifically, referenced a format not in use until 2011. When Judge Wren asked Clifford Vance to address this, he said that the examiner's conclusions were a matter of expert disagreement and that they intended to present their own expert. The judge made a note. Her expression did not change, but she made a note. Then Ray was examined. I watched my son in the witness box, and I thought about how well I knew him. His voice, his posture, the way he held his jaw when he was uncomfortable. He answered Margaret's initial questions carefully and within the range of his prepared answers. But Margaret is a methodical attorney, and she asked questions in a specific sequence, circling, and the sequence mattered. She asked Ray to name the lending institution. He named one, Consolidated Private Lending Solutions. She asked when it had ceased operations. He said 2014 or 2015, he wasn't certain. She asked for any documentation of his transfers to this institution on my behalf. He said the records had been lost when the company dissolved. She asked how he had obtained contact information for this institution and who had referred Edward to them. He paused. A genuine pause. Not a thinking pause, but a searching pause. And said he believed it had been through a colleague of his father's. Margaret asked the colleague's name. Another pause. He gave a name, Margaret said quietly, that she had subpoenaed the employment records of that colleague and that the individual had been employed by the county in a department entirely separate from Edward's, had no financial industry background, and had submitted a signed affidavit stating that he had never discussed private lending with Edward Hayes or with Raymond Hayes. Ray's answer to this was technically coherent, but internally inconsistent in a way that I could see Judge Wren tracking. She asked one clarifying question herself at that point, a single question about the timeline of Ray's first contact with the lender. And Ray gave an answer that contradicted what he had just said by approximately 2 years. Linda, on the stand afterward, had clearly been coached to keep her answers short and her demeanor stable. For most of Margaret's examination, she succeeded. But when Margaret asked whether she had been present at the kitchen table conversation in April 2009, when Ray had first told me about the debt, Linda said no. She had been at home with the children. Margaret asked if Linda had been aware of the $500 monthly payments. Linda said she had known that Ray was managing his mother's finances to some degree in the years after Edward's death. Margaret asked what she understood managing finances to mean. Linda said she had not asked for details. Margaret said, "Mrs. Hayes, your household received $47,000 in April of 2009 and an additional $43,000 in payments over the following 15 years. You were not curious about the source of any of that money?" Clifford Vance objected. The judge overruled. Linda said after a moment that she had understood the money as related to an inheritance matter. Margaret asked her to clarify what inheritance matter. Linda said she would need to consult with her attorney before answering. The courtroom was quiet. Judge Wren looked at Linda over her reading glasses for a moment. Then she made another note. At the close of the hearing, the judge did not issue an immediate ruling. This was a civil proceeding, and she would issue a written decision within 30 days. But she asked Clifford Vance directly whether he intended to produce the promised expert to contest the document examination findings. He said yes. She said she would note the court's expectation and set a deadline. Then she looked at me. At least I felt she looked at me, though perhaps she was looking at the room generally. And she said, "The court has reviewed the submitted evidence. The pattern of financial transactions described is well documented. The court expects all parties to be prepared for a thorough proceeding." I walked out of the courthouse on a Wednesday morning in June and stood on the steps in the warm air and thought, this is what doing the right thing feels like. Not triumphant, not vindicated yet, just clear. The written decision arrived in Margaret Ellison's office on a Friday morning, 26 days after the hearing. Margaret called me at 9:15. I was in the garden, which is where I often am in the morning in June. I came inside, washed my hands, and sat at the kitchen table. Margaret read me the key findings. Judge Wren had found in my favor on all counts. The court determined that the evidence clearly established a pattern of financial exploitation extending from April 2009 through March 2024, totaling $90,000 in documented payments made by the plaintiff to Raymond Edward Hayes. The document produced by the defense as evidence of the original loan was found to be inconsistent with its claimed date of origin based on the forensic document analysis, and no credible evidence had been submitted establishing the existence of any loan taken by Edward Arthur Hayes. The court found that Raymond Hayes had obtained funds from the plaintiff through deception, and that Linda Christine Hayes, as a knowing beneficiary, bore secondary civil liability. The judgment: full restitution of $90,000 plus 8% statutory interest calculated from the date of filing, plus the plaintiff's reasonable legal fees. The total, Margaret told me, would exceed $110,000 once all calculations were complete. Additionally, the court referred the matter to the county prosecutor's office for review of potential criminal charges under Ohio's elder abuse statutes. This was the part Margaret flagged as significant in a different way. It was not a conviction, it was a referral, but it meant that what had been a civil matter might become something more serious for Ray. I sat with the phone in my hand for a moment after Margaret finished speaking. Then I said, "What happens now, practically?" Margaret explained that Ray and Linda had 60 days to comply voluntarily. If they did not, the judgment would be enforced through wage garnishment, bank levy, and, if necessary, a lien on their property. Ray was a salaried employee of an engineering firm. Linda held a real estate license and commissions that were traceable income. They were not judgment-proof. Collection, she said, was realistic. I thanked Margaret. I asked her to send me the written decision when she had it. Then I went back to the garden. I want to describe what the next few hours were like because I think it matters. I did not cry. I did not open a bottle of anything. I pulled weeds for a while, slowly, and I thought about Edward and about the green notebook in the drawer beside the stove. I thought about the fact that he had spent 41 years being careful and honest, and that what had been done to his memory, the fabricated debt, the invented loss, was in some ways the thing that angered me most of all. They had used his death as an instrument. They had waited until he was 3 weeks in the ground, and then they had taken a forged piece of paper to the kitchen table. That was the part I could not make peace with. And I did not try. Carol called an hour after Margaret. I told her. There was a silence, and then she said, "Mom," just that. Then, "I'm so glad." The certified copy of the judgment arrived by mail the following Tuesday. I read it at the kitchen table, all 14 pages, and then I put it in the manila folder now labeled Final Judgment, and I placed that folder in the fireproof box where I keep important documents, next to the deed to the house and Edward's pension records. Ray did not call. His attorney communicated with Margaret's office. They requested the 60-day compliance window in full, which was their right. Within 2 weeks of the judgment, the consequences had begun to accumulate in the way that legal and financial defeats tend to, quietly at first, then with increasing weight. The referral to the county prosecutor became public record, which in Ohio is accessible. Ray's employer, a mid-sized engineering firm where he had worked for 14 years, placed him on administrative leave pending an internal review. Linda's real estate brokerage was notified through a routine license check that she was party to a civil fraud judgment, which created complications with her professional standing that her broker described, when Carol looked into it, as a matter requiring resolution. They did not pay within 60 days. Margaret filed for enforcement. A lien was placed on their home. A bank levy was initiated against Ray's primary account. His wages became subject to garnishment, the maximum amount permitted by Ohio law. Linda's commission payments were identified and made subject to collection. It would take time. Margaret had told me it might take several years to collect the full amount through enforcement, depending on their ability to pay. I understood this. I was not in financial distress. The $90,000 had been taken incrementally over 15 years, in amounts that had been manageable though significant. The money's return would be welcome, but the outcome was not only about the money, it was about the record. The written, legal, publicly accessible record of what had been done by whom and when. Judge Wren's 14-page decision would exist for as long as court records exist in Columbus, Ohio. It named Raymond Edward Hayes. It named Linda Christine Hayes. It described, in formal and precise language, what they had done. I had made sure of that. By the following spring, March of 2025, almost exactly a year after the bank's letter had arrived, my life had settled into a shape I recognized as genuinely my own. The garden was coming in early. The tomatoes I planted each April had become a kind of personal almanac, and that spring I tended them with a thoroughness I hadn't managed in years. I fixed the fencing, built a proper trellis for the heirloom brandywines Edward had always preferred. I bought a new trowel because the handle on the old one had finally cracked, and I did not feel guilty about spending $15 on it. That sounds like a small thing. It was not. For 15 years I had lived with $500 leaving my account every month, economizing in ways I had never named to anyone, including myself. The new trowel was a small, concrete version of the larger truth. The money was mine again. Margaret Ellison's office continued to pursue enforcement into 2025. By March, approximately $42,000 had been recovered through garnishment and levy. The lien on Ray and Linda's home remained in place. Full recovery would take another 2 to 3 years, but I had time. Ray's professional situation had not recovered. He had been permitted to return to his firm after administrative leave, but was passed over for a senior position he'd expected to receive. Linda's real estate license was placed under a supervision requirement by the state board, and her production numbers had declined sharply through the second half of 2024. More significant was what Carol told me in February. Ray and Linda had separated. Stephanie, who had quietly stayed in contact with me throughout, cards at Thanksgiving, a call at Christmas, told Carol their marriage had been under strain for years before the lawsuit. The lawsuit had simply removed the last infrastructure holding things in place. Deception corrodes not just the people deceived, but everything built on top of it. Carol flew in for a week in May, and we repainted the front porch together. 2 warm afternoons with the dark green paint Edward had always used. We talked easily, the way we had when she was growing up, and the way we hadn't always managed in the years of keeping the peace at family gatherings. I found I no longer needed to manage anything in that way. Ray called twice since the judgment. At Christmas, he mentioned the boys had asked about me. I told him my door was open to them, as it always had been. He said thank you, quietly, in a voice I recognized from when he was small and had broken something and was hoping to be forgiven. I did not tell him he was forgiven. Not yet. Perhaps not ever, in the complete sense. But I did not close the door either. That felt right. Not warm, not vindictive. Just accurate. The cardinal still came to the feeder on the maple tree. Edward would have said it was sentimental to find meaning in that. He would have been right. But he also, I think, would have been pleased with how I'd handled things. 15 years. $90,000. One letter that changed everything. What I learned is this. Trust is not weakness, but unexamined trust can be. Keep your records. Read your mail. Ask the questions that feel rude to ask, because the people who want to deceive you are counting on your politeness. And if you discover the truth, however late, however painful, it is never too late to stand for yourself. I was 72 years old. I acted anyway. What would you have done in my place? If this story reached you, please leave a comment or share it with someone who needs to hear it. Thank you for listening.